us while we're waiting for Sister Nyari to connect.
Okay.
Thank you. You are, I think, Sis Connie, you are on mute.
Oh, okay. I'm still looking to see what we can see.
Okay. All right. While they are still organizing themselves, I would like to ask all of us, if as we are coming in, if we can mute our gadgets so that we minimize the background noise, that will be very helpful. Thank you so much.
I'll sing hymn 73.
Thank you. Go ahead.
Mambo wedu atidaidza kuchidyo chake chekudenga tomira senyi mukutongwa mambo apinda apo mambo apinda kuzotitonga tichamira senyi apo mambo apinda mambo Jesu anechiremba pakange pazoiswa minzwa nembiri yake tichamona mambo apinda apo mambo apinda kuzotitonga tichamira senyi apo mambo apinda tenzi tinokumbira mutsa kuti tese tinozomira munzvimbo dzedu nekusatya mambo apinda apo mambo apinda kuzotitonga tichamira senyi apo mambo apinda. Amen.
Amen. Amen.
Amen. Thank you, Sis Connie. Is Sister Nyaradzo here now? Elder?
I am checking. She is not yet, but she will be with us in a minute.
Okay. We'll do one more song while we are waiting for Sister Nyari. I'll just ask that may we be patient with her as she connects. Where you may lead me, I will go. for I have learned to trust him so. And I remember it was for me that it was slain on Calvary. Jesus shall lead me night and day. Jesus shall lead me on the way. He is the truest friend to me, for I remember Calvary. Oh, I delight in his command, love to be led by his dear hand. His divine will is sweet to me, hallowed by blood-stained Calvary. Jesus shall lead me night and day. Jesus shall lead me all the way. He is the truest friend to me, for I remember Calvary. Onward I go, no doubt, no fear, happy with Christ, my Savior dear, trusting that I someday shall see Jesus, my friend of Calvary. Jesus shall lead me night and day. Jesus shall lead me all the way. He is the truest friend to me, for I remember Calvary. Amen. Is our sister here, Elder?
Not yet.
Oh. Um, I'm going to ask someone else to share a song with us while we exercise patience and gentleness and wait for Sister Nyari to log in. Sister Metron.
Hello, Sister Patient.
How are you, my dear?
I'm all right, thank you. And how are you?
I'm well. Are you in a position to share a song where you are? Are you able to share a song with us?
Yes, I will. Let me just look for a song.
Okay, thank you so much. If Sister Nyari enters, Elder, will you let us know, because I might not be able to see her?
I'll do that.
Okay, thank you.
I'll sing one stanza of a song that's called He Became a Man. He became a man. Christ became a man and laid aside the glory and all to be a carpenter, a simple carpenter, a lowly servant, rejected by his own. But God exalted him, God has uplifted him, and has given me above him no divinity above him.
Amen. Thank you, Sister Matron.
Sister, I just spoken to Sister Nyari. She's just joining. Said give 5 minutes. She will be in.
5 minutes. Okay. Right. Elder Mnangati.
Yes.
Any maybe if you can just announce what the program is all about this evening for those who are just joining us while waiting for Sister Nyari.
Yes, we can do that.
She's here.
Okay with that background.
Has she joined us?
Yes, she's here.
I think you can give it the time. Let me just welcome Sister Nyari. Sister Patience will still welcome the church. I just want to welcome Sister Nyarazo Maposa, Advocate Nyarazo Maposa. We have one of our own who is working in the legal field in Zimbabwe. All our legal issues, she's able to address them, but tonight she is going to deal with the Marriage Act of Zimbabwe. We know that there was some changes on the Marriage Act in Zimbabwe. She presented during the Zim Fellowship on Saturday, and some who were there, they had some questions and so on. So tonight we decided that she will present, whether she will answer questions or she will highlight some major issues in the Marriage Act. It will benefit all of us, even those who don't come from Zimbabwe who are amongst us. It also applies in our relationships, as I said before. Advocate Nyari Maposa, you are welcome.
Thank you so much, Elder.
Sister Patience, back to you.
Thank you, Elder, for the introduction. I would like to take this time to welcome everyone who has joined the GAP family this evening to listen to our Sister Nyari as she shares this message with us. I pray that may all of us be blessed. And I suppose if there's anyone who has any questions, if we could be writing them on the chat there as well, they could be taken note of and forwarded to Sister Nyari for answering. Thank you so much. It's your time now, Sister Nyari.
Thank you, Sister Patience. Thank you, Elder Mnangati. May I start by apologizing? Sorry, I think there was a bit of communication breakdown because I know that we'd confirmed for Tuesday, but I think I didn't know the time, and I probably needed a reminder. My apologies for that. But good evening, everyone, and I trust you had a wonderful beginning of the week. How we will go ahead and deal with the matter is, I will just give you a very brief recap, especially for those who are not around on Sabbath, and then I will take questions, okay? I would like to attend to this as mainly taking questions. So, first and foremost, we spoke about the types of marriages in Zimbabwe, and the first one being the civil marriage, and that is the monogamous marriage. That's the one we know as chapter 5:11 or chapter 37. And this one obviously allows only for one husband and one wife. And if either of the spouses engages in a relationship with another person, then that is adultery and can be sued in a court of law for adultery damages. If they get into another marriage, whichever type it is, then it is what we call bigamy. All right, it's actually a crime and you can be prosecuted for that. Essentially, I emphasize that the law is very serious about the vows that you enter into and the marriage type that you enter into, and expects you to take those vows very seriously. And because of that, it does allow for recourse if anybody then goes outside of the marriage contract that they made. All right. Secondly, you have the registered customary law marriage, which of course is not the marriage that is recognized within our church, right? This one is the potentially polygamous marriage, which used to be called chapter 238, but now is called chapter 507. Okay, so this is when two people get married, they go to the magistrates, they register their marriage, and they have to prove that lobola was paid, and because it's customary, and it's potentially polygamous. It's not monogamous, it's potentially polygamous, meaning should the husband, not the wife, should the husband choose to have more wives, the law allows them to do that, and they can register further marriages as time goes on. Obviously, we can see that this one is a bit tricky in terms of security, etc., etc. And most people who enter into these marriages, they don't have the full understanding of what it means. But again, the law will give latitude according to one's choice. Then we go to the unregistered customary law union. This one is very important because I think I mentioned that a lot of people within our church, especially I think back home, they have that kind of marriage, okay? And at law, you'll notice we call it the unregistered customary law union. They don't even recognize it as a full marriage because it doesn't have a certificate. And as you know, it applies both to someone who might register under the registered customary law marriage or under the civil marriage, because culturally we pay lobola in order for a couple to be considered married. So unfortunately, at law, this marriage, which is the unregistered customary law union, which we call UKLU, is potentially polygamous. Okay, so we need to understand that it's potentially polygamous. It's under the customary law. It means it allows for polygamy. So if there's anyone who is married and they don't have a certificate which says this is a monogamous marriage or it's a civil marriage, it means that a husband can go and get into relationships and marriages with other people, and the law will be okay with that. And I found a lot of women, even within the church, having some problems because they did not register their marriages beyond the payment of lobola and the customary rights, which then took effect. So my advice, of course, here is that after lobola is paid, go and register your marriage. And now it's actually a legal requirement. The New Marriage Act, which is chapter 515, indicates that after lobola has been paid, even if it is not fully paid, but once the families agree that you live as husband and wife, then you must register your marriage with, it says within 3 months. That's what they said, within 3 months of the payment of lobola or the acceptance by the family that you're now man and wife. So please ensure that you do. And of course, like I said, within our church, we only accept the civil marriage if we're going to have it registered. And it secures a lot of things, okay, and just gets rid of a whole lot of problems that people get into when the marriage is not registered. And if the marriage is registered, what it essentially means is that let me say, if the marriage is not registered, you just had lobola paid for you. Yes, in the church, you are accepted and you should be accepted as a married couple. I know that there's a blessing that comes with a pastor, and people are announced in the church that these two have paid lobola for each other and they are recognized as a married couple, so they can take church positions. However, at law, it is only registered for the purposes of, first of all, legitimacy of children. So your children are considered legitimate, for guardianship, and fathers are normally the natural guardian of all children, of children under 18 years, and custody mothers are the legally recognized custodian, natural custodian of all children, and then access. Okay, where it comes to maintenance, there is a mutual duty to maintain all children, okay, between parents. So there's no greater duty on the mother to maintain the children or on the father. So that's just something that we need to know. And then comes the third one, which has now caused a bit of an issue, and that is what we call living in, okay, or people just shacking up together, just boyfriend and girlfriend, they move in together and they start living. So because of the high occurrence of this situation, the law has had to look at these arrangements to see how things can be equitably dealt between couples. So one thing we need to know is that the law does not moralize, okay? So always understand that we have the church side of things which are moral, and that standard is pretty high, okay? But when the law is dealing with people and dealing with couples, it does not moralize. It doesn't look at what are the high moral standards of society, okay? It doesn't look to say, what does your church say? The law will be applied equally to everybody. And so whenever we're looking at legal issues, it's very important that though we are looking at everything in terms of what the Bible says, we also need to be savvy and knowledgeable about what the law says, because the law is not only dealing with Christians, and the law is also not only dealing with Adventists. And you might find that your partner or your spouse might end up using the law, okay? And you'll find, the law against you, okay, like within a marriage. So you will find that, Okay, sorry, I was just having problems with my battery. So you will find that if a person is in an unregistered customary law union, and they then have, let's just say the husband has started a relationship with another person, you'll find that it's hard for that person to sue the other woman, for instance. It's hard for you to protect yourself, right? Why? Because the unregistered customary law union, though recognized in our church, does not protect the wife from other women because it is customary. So we need to understand that. That's why it's so important that marriages go and get registered. And within the new act, there is a requirement that all marriages where lobola has been paid, that you go and have it registered. All right. And so that is absolutely, absolutely important. Now, we've got those 4 arrangements normally that you find in society. And I've explained the first one, I've explained the second one, I've explained UKLU, which is your unregistered customary law union. And then I think I sort of touched on where people just live together. Now, I want to talk about the new Marriage Act and what has changed and what has not changed, all right? So first and foremost, the new Marriage Act did not allow small houses at all. It did not do that. And we just need to understand and accept that. I know that on social media and popular sites, there's a rumor that small houses have now been allowed. They have not. If you go through the whole act, if you go through the whole act, you will notice that nothing says that small houses are now allowed. If anything, the law is not supporting small houses. And why we say so is usually when Parliament passes a law, they are dealing with what we call a mischief. Okay, so first of all, in order for the courts to interpret a law, they look at the mischief or the problem that the legislature or parliament was trying to resolve when they made this act, or when they promulgated a certain law. Okay, so I will go in and tell you what Parliament was trying, the problem that Parliament was trying to deal with when they came up with this Section 41 of the New Marriages Act, which talks about civil partnerships. Okay, they were not referring to small houses at all. Okay, and they have gone out of their way to try and demarcate between small houses and the situations that they were trying to deal with. So the first situation that the law was trying to deal with, I'm still discovering more reasons why this act came into being, or why this particular civil partnerships clause was included in the New Marriage Act, but I'll give you a few. The first one is that situation where we all know that there was a huge exodus out of Zimbabwe, right? To other countries, whether South Africa, the UK, the US, Australia, Canada, etc. And right at the beginning of that exodus, there was no automatic allowance for spouses to join the spouse who would have moved to those other countries. So let's just say here in the UK, what happened is there was a huge need for nurses and people doing care work. And so naturally, the nurses in Zimbabwe, being primarily female, okay, it was the women who made the biggest exodus into the UK. And their husbands were not necessarily given work permits or allowed to come and join their wives, and vice versa, of course. And because of that, for the longest time, people then, while being here, they started relationships with other people, right? They started relationships with other people who were in the UK, right? So this is a married woman who has her husband back in Zimbabwe, who is working in the UK and sending money home. And they're building, houses, they're buying cars, they're sending children to school, etc. And she is breadwinning. But that's obviously because we are human beings, right? It did not stop people from entering into relationships with other people. And that is the situation where it says that a married person can be in a civil partnership. Okay, they're not talking of small houses. They're talking of where you are separated from your spouse for a long period of time, and you enter into a living in relationship with another person. So this woman comes from Zimbabwe. She leaves her husband back home. She comes here. She enters into a relationship with a gentleman, and they move in together and they start living together as husband and wife, and for a long period of time. And where that happens, surely people are going to buy fridges. People usually will buy property together. Okay, they're going to buy sofas. They're going to buy beds, sometimes even tracts of land, right? But there'll always come a time when people now are breaking up. And when people are breaking up, remember, this breakup, you don't need to go to court in order to break up. If you are in a civil marriage, the chapter 511, you have to go to the High Court in order to get a divorce. If you're in the customary marriage, you have to go to the magistrate's court in order to divorce. But when you are shacking up with someone, you just break up with them, okay? And that's it. And so there was no forum on which people or parties could go and challenge and say, yes, I was living with this person and we're living together for the past 5 years or for the past 2 years, etc. We need the court to please share the property that we purchased together. There was no forum for that. And so this civil partnerships clause or chapter was included so that there is a platform through which or on which parties could approach the court and say, yes, we were not married, okay, number one, not legally in the way that people understand, but we did accumulate property together. We did share, responsibilities, and, I did contribute to this person's well-being or etc. And because of that, now we are breaking up. We need the court to fairly distribute the property that we accumulated. Excuse me. Excuse me. So the court was being faced by so many of these claims. The women who had gone abroad, the men who had remained behind. The wife is in the UK for so long, right? So he ends up being in a relationship with another woman. He's not married to her. He hasn't paid lobola, hasn't done anything. And, or even sometimes he has paid lobola. And he starts living with that woman, but he has not divorced his wife. And there always comes a point where the two are breaking up. And the problem at court came when people were dissolving their relationships, or where one of the parties then died. Then the court had to fairly distribute whatever properties or property that they had acquired together. And that was the first mischief that the court was trying to deal with, where, yes, somebody was living with someone and they lived with them maybe for 15 years and they didn't get married, okay? But obviously, property was acquired. And when they were breaking up, there was a whole big wrangle to say the fridge belongs to me, not the sofas were mine, no, I'm the one who got, the loan from work in order to buy this car or to buy this house, this apartment, etc., etc. And so the court decided to put this civil partnerships clause in the Marriages Act so that it can treat people fairly. And I think I remember mentioning that the bedrock for this particular clause, or for our law, is to say there must never be unjust enrichment at the expense of someone. So if somebody put their labor, I mustn't benefit from it unless they agree or unless they are consenting. But if somebody contributed to a relationship, whether indirectly or directly, it was their life, it was their time, sometimes it was their money. And so the court will say, no, we will not just let this man go without benefiting from his contribution, or we cannot let this woman go. I know you are breaking up, or I know that one of them has died. There will be a claim, against the estate in as far as the contribution that one of the parties or the surviving party made. I hope we understand that. So a small house cannot be a civil partner, because there's never a point, or there's hardly a point, where unless there's a huge absence of your spouse, that you will be living with another person as husband and wife for a long period of time. Okay, so usually with small houses, these are just girlfriends. Sometimes, yes, it's somebody whom a person is renting a flat for, or they're coming from work and they pass by and see their boyfriend or their girlfriend, and then they go back home. But their actual home, if they were asked, where do you live? It will be with their spouse. As long as that arrangement is there, this other person is not a civil partner. They are just a girlfriend. They are a small house, or I don't know if they are males, what they are called, a benten or something. But ultimately, the only people who will be considered as civil partners are people that you actually lived with over a period of time. It doesn't say the minimum time, but one thing I have observed is that it's never less than a year to actually live with that person continually, day after day. And while I am there, I'll just do a quick run of the requirements that the court will look at before it determines that you're a civil partner. And why it's important that a person in such a scenario is considered as a civil partner is so that even the indirect contribution that they might have made to benefit the life of their partner, that it be considered and monetized, if I can put it that way. And if this person died and they have an estate, the civil partner will have a claim, a small claim in the estate because they also contributed. So I'll give you just a brief rundown. The first one, it says, of course, the two must be both over the age of 18 years. And it says they have lived together without being married to each other. So they have lived together, not that they are in a relationship or that they pass by and visit every so often. No, they must have actually lived together, okay? And then it says that they must be a couple that is living together on a genuine domestic basis. Can you believe that? So it actually says these people must have lived together as if they are man and wife every day, day in, day out, right? Having the same meals or buying the same grocery or living within the same home. Again, you will notice that, oh, I beg your pardon. Again, sorry, just having a problem with my battery. So again, you will notice that the law is requiring that before they can call a person a civil partner, they need to have lived together on a genuine domestic basis. And I was thinking, what is a genuine domestic basis? If you think of it, it's quite a hard thing to prove. It means that one must show that indeed, if the neighbors were to be asked to say, is this husband and wife, if they didn't know better, they'd say, yes, it is a husband and wife. Not that the husband would visit twice a week or, sometimes after, hoodwinking the wife or the wife hoodwinking the husband, then they visit every so often. No, the law says proof that your relationship was on a genuine domestic basis. You were the wife, not only to look at conjugal rights, but this was the husband and this was the wife, and that is what it looked like even on the surface of it. So if it was just a person you visited every so often, or a person who does not live with you, they cannot be considered as a civil partner. All right, then I'll quickly go through the requirements. It says the only time that the court will consider whether or not two people were in a civil partnership is upon dissolution. This is very important. So it does say that upon dissolution of any relationship, this will apply. So when the relationship is extant or it subsists or it exists, there is no institution called a civil partnership, okay? It is not there. If two people are living together, that's what they are doing. It is actually not a lawfully or legally recognized relationship. If a woman who has come to the UK and her husband is in Zimbabwe and she has started a relationship with someone here, please, no matter how long it is, please know that it is adultery. And that husband, if he finds out, is very free to sue this other man for adultery damages. So the law is not recognizing the existence of an institution. That's why the act was very specific to say we will only consider whether or not an arrangement was a civil partnership when people are breaking up and they come to court and they are fighting over what? They are fighting over property. Or if a person has died and maybe a man or a woman feels that they have a claim in the estate by virtue of their contribution, whether direct in terms of money or indirect in terms of just being supportive. I hope that is very clear. It then says the circumstances that the court looks at are as follows. The duration of the relationship. So obviously, if you were together for 6 months or 8 months, maybe even for a year, I don't think that it can be considered as a civil partnership. It has to be much longer. There must have been a show of some kind of permanence and plans to be together for a long time. The second one says the nature and extent of their common residence. You see, so the court is actually saying we need to see that you are living together. Otherwise, we are not interested. Okay, you are not a civil partner and you will not get the court will not look at your indirect contribution, right, to this partnership. Then it says whether a sexual relationship exists. Okay, that one is a given. Then number 4, it says the degree of financial dependence or interdependence. So already you can see also that this excludes small houses, because normally with small houses, it's a one-way street. It's the man who is looking after the woman, the girlfriend, okay? So if the courts cannot see that she was also, contributing, okay? She was also contributing, and that if this man were to get into an accident, or if he were to, and he can't work, or if he were to be retrenched, then she would look after him. If the court cannot prove that, then it's not a civil partnership. And where it comes to the women, they can say, this one is a Benton, she was just looking after this one. It was a transactional relationship, something of the sort. Then it is not a civil partnership. So the court will look at the degree of financial dependence or interdependence. If it was one way, chances are the court will say it is not a civil partnership. Then the next thing it says the ownership, use, and acquisition of their property. So you can see that a person would not normally contribute to the purchase of property if they didn't think that the relationship that was between them is a permanent one, or there's an intention to continue together on a permanent basis or on a long-term basis. So the court will look at that to say, what was your contribution, when this property was bought, okay? Then we look at the degree of mutual commitment to a shared life. Again, the law is specifying that you need to have proved that we actually meant to live together for a long time. You actually need to prove that. If it was just temporary and the court can see that, no, this was just one person benefiting from the other person, and they had no intention to actually continue, together as a couple for a long time, then it is not a civil partnership. Then it goes on to say the care and support of children. That one, I think, is a given. Usually when people end up having children together, when they're living together, there is the assumption or presumption that you intended to live together for a long period of time. Then the final one, which always interests me, is this one that says the reputation and public aspect of the relationship. Wow. So already that is telling you that it's very hard to qualify as a civil partner if you're just having a casual relationship with someone and there was no intention to be with them till death do you part, okay? Or as a side arrangement. It's really, really hard. So when the court says, and here the law is actually moralizing, it says the reputation of the relationship. And if people know that this man is married, surely, and he is now living with another woman, and society looks down upon it and frowns upon that, the court will be inclined not to declare that to be a civil partnership. I hope you understand that. And then it says the public aspects of the relationship. Wow. So again, if the church is not accepting that relationship, if the general public is looking down upon that relationship, if it is not accepted, okay, then the law will not consider it to be a civil partnership. Okay, so if you're out here in the UK and you're living with a person and you are married, the people around generally don't know that you're married to someone else back home, right? That's why these arrangements usually survive even public scrutiny, besides the fact that usually people mind their own business around here. But at church, if you are living with someone, the church will look at it and say, what do we think about this arrangement? Are the two of you married, etc., etc.? And the church discovers that you are shaking up together and you're not married. You will face church discipline, and the court will not look at it as a civil partnership, and you will not benefit from such an arrangement. I hope that one is clear. So a person, a spouse can sue a girlfriend or a boyfriend of their spouse for adultery damages, they still can. And I think I indicated Justice Zisengwe, he then immediately gave a judgment sometime, I think in February, of about $13,000 in adultery damages to the wife, of the wife of the man who was cheating. And that one went quite viral because then it countered what everybody else was saying, to say small house apinda, or small houses are now allowed, people can have relationships, etc. And I keep on saying the law is not confused. It will not blow hot and cold to say, number one, we have a monogamous marriage where it's one woman, one husband. And then in another breath, they say, oh, but then it's also okay to be in relationships with other people. That cannot be correct. All right. Then just one thing that I can say as I move on to the next thing is that what I found interesting is right at the end of it. Let me read this. I think it'll be actually better if I read this out. It says, let me see. Right. So it says, this is subsection 5, right? And it says, when one of the persons in a civil partnership is legally married to someone else, a court that is determining the division of property, like what I have said, it's only at division that this civil partnership story is raised. As long as it hasn't been raised, it hasn't gone to court, it is adultery or it is puchaya mapoto, and it is looked at for what it is, okay? But when the court is trying to determine how to equally distribute property of two people who are breaking up, but they were not married, that's when they start to look at whether they were a civil partnership or not. So it says, when the court is determining the division, apportionment, and distribution of assets, they shall pay due regard to the rights and interests of the spouse of the civil partner, and ensure that its order shall not extend to any assets belonging to the spouse. Wow, is that not interesting? I thought this was amazing. So instead of going against marriages, this law actually supports marriages and is more to protect the rights of the spouses. So I go back to my example again, where we have a lady who's moved from Zimbabwe. She has come to the UK. She has entered into a relationship with another man, and they're just shacking up together. And then they're breaking up, and this man has got some claims. The court says, while it is determining that man's rights, they will first of all ensure that whatever his rights, they do not prejudice the rights of the spouse back home. Wow. I thought that was just the most amazing thing. So the law is actually saying, no, we want to protect the marriage assets. And somebody wants us to say, is it possible? And yes, it is possible. Is it possible that, while a man is in a hearing concerning a civil partnership he entered into, and he wasn't, say, paying maintenance for his children, but he bought his girlfriend or his civil partner, let's say, a Mercedes. Can the wife say, well, what made him afford to buy that Mercedes was the fact that he wasn't contributing to home. Okay, he wasn't contributing school fees. I was paying the school fees. That's why he had money to be going to restaurants and buying things for this lady. Are we together? So those are the things that the court will be looking at to say, wasn't the wife, the spouse, prejudiced while this man was building this other relationship or living with this other woman? And vice versa, did the husband not suffer prejudice by the fact that this woman was directing her energies to this relationship that she was in, and not either supporting back home or not doing what she was supposed to be doing financially? I hope that is clear. All right. By the way, anyone who has questions, please go ahead and send them to the chat. And I think my elders will send them to me on my phone, on my WhatsApp. Then I'll try and explain those. Okay. Now let me move on just with, I think I was also giving you examples of the typical examples of civil partners, okay, civil partnership, where the court would say, okay, now this was a civil partnership. The second instance is, of course, where, okay, I'll give you an example. I think this is your uklu. I mentioned about uklu. So you will notice that if you have lobola paid for you, or rora paid for you, or your dowry, right, paid for you, but you then did not register that marriage, okay, whether it's under 507 or 511, you didn't register, you just got lobola paid for you, or you just paid lobola for the woman, right? And I said it's potentially polygamous. You are in a typical arrangement of a civil partnership. You are living with a woman or living with a man without being married in a legally recognized arrangement, okay? And because of that, when you are breaking up, you don't need to go to court to break up. And I'll ask you, what's the typical way of the customary way of divorcing a woman? You will all agree with me that it's gupuro. I'm not sure what it's called in Ndebele, but it's what we call the divorce token, and it's a small amount, a very a tiny amount, okay, which is really supposed to show that you don't care for this woman anymore. Now, because customarily, okay, and legally in a limited sense, if you have lobola paid for you, you are accepted as a married woman. In society, it's okay. It's a type of acceptable arrangement which can be recognized as a marriage. But customarily, when you get a divorce token, you just walk. You carry your bags. They say the bags that you came with. I don't know if after 25 years, a woman can remember what she came with, but they'll say you do not take anything else, because whatever your efforts and whatever your energies and your contribution, you were contributing to your husband's family. Now you go back to your family because you've been given a divorce token. So those cases became rife in court, where these women typically would go to court and say, but I was married for 25 years to this man. Yes, he has given me a divorce token. He's found a younger person or someone more interesting, whatever the case may be. Now he has given me a divorce token, he's told me to go. But the Scotch cat that is here, I'm the one who bought. I also have cows here, which I contributed to, I also bought. Or we bought a house together, right? Or we bought stands together, or we bought furniture and property together. But now, because I'm married customarily and there's no court which is required for us to divorce, I am now walking with nothing. Then the court, the law looked at it and said, oh, okay, so this is a mischief in society that is happening, that women are being divorced without taking anything, right? Because customarily, when she was married, she joined the family of the husband, and now she's been told to go back to a house. But when we're looking at property rights, not being matrimonial rights or those personal rights that between two married people, just looking at the law, no one must benefit from your labor and your contribution at your expense. And so the court looked at it and said, right, this is one of the situations where we can apply the civil partnership law. Okay, so this uklu is your typical arrangement of a civil partnership. Okay, so this, and remember, it's a civil partnership, but it's people who went and paid lobola, people who are married, right? But because the law is limited in terms of dealing with that particular arrangement, it will probably let it fall under section 41. I hope that we are there. And then the other typical one, where you can understand the mischief that the court was trying to deal with. All right. This is where you have a woman who is married under the civil law, okay, married under the civil law, and she separates with her husband, but they do not get divorced. Okay, she just goes away. She goes back to her home, they say where she came from, or she just moves to another country. And this is very, 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 very common, where the couple is separated, but they don't divorce. They don't divorce at court. All right. So they remain legally married, but practically and physically separated or divorced. Sometimes they don't even have any, you know, they don't have the intention of coming back together, and they just separate and they go different ways. Then maybe the husband remains, he marries another woman, and he goes and pays lobola for her, and then it becomes a challenge, you know, upon his death to then say what happens. I'll give you an example that I normally give. This one helps people understand that situation better. Where a man was married to a woman in the 1950s, 60s, somewhere there, he then separated with his wife, and he approached the High Court for a divorce. The High Court refused the divorce because they said there is no valid reason why you are divorcing your wife. And because at that time you could only divorce for the cause of adultery, that was it. Anything else, you could not divorce. So he approached the court about 3 times, and the court kept on saying no. In the meantime, he got into a relationship with another woman, went and paid lobola for her, and they started having, you know, children, of course, and they built a huge empire. Okay, they were very, very wealthy as a couple, right? This man and with this woman who was the subsequent wife. That wife kept on resisting being divorced. Then eventually the High Court said, okay, fine, you can divorce. I think that was around 1976. And but the original wife, what happened to her? She appealed to the Supreme Court, challenging what the High Court had said to say you can divorce. And in 1980, right, 4 years after the High Court had said you are divorced, the Supreme Court overturned the High Court judgment and said, actually, the High Court was wrong. You are not divorced, you're actually still married. You can imagine how hard that was. And what makes it worse, later on, maybe 30 years later, what happens? The husband passed away. And guess what happened? This wife comes, this is the legal wife, the first wife with the Chapter 511 marriage and the certificate. She comes and she waves her marriage certificate and she says, well, you know what? I am the surviving spouse. So his estate and everything belongs to me, because that's what the law now says. So the law then, you can see that that's a difficult situation where the whole country and the whole world knows that the person who actually built this empire with this man is the subsequent wife. And the reason he did not divorce the first woman is because the court wouldn't allow him, because the considerations were different. So obviously, the court had to look at it through a different law, and the law that they were looking at it from or through was this civil partnership. And they said, fine. So this woman was married, she is the legal wife, but the subsequent woman was a civil partner, and her contribution must be fully recognized. And this woman, though she was legally married, she cannot benefit from the sweat of the second woman. So the law was not moralizing, but it understood that people, they get into these situations, and at that time the man could not divorce, and he really truly built his empire with the second woman. And so they used the civil partnership in order to protect the rights of the subsequent woman. I hope we do understand that. All right. Now, I think I mentioned about wills and inheritance and trusts. And before I take questions, because I think our time is running, I did mention that with trusts, trusts are essentially legal personalities, or they're like they're like companies where you are creating a legal person who is not human, but that person or persona has got rights and can sell and buy and can sue and be sued, etc., etc. And what is important with removing yourself from ownership of an immovable property into a trust? The law looks at the trust as an individual person. And so should you die, the property that has been put in the trust will not be considered as part of your estate because they already belong to another person who is the trust, okay? But the good thing about it is, if you are running a family trust, you are still running your properties and everything as if it is you. You are just doing it in the name of the trust. Okay, so you are kind of like a shareholder in a company, all right? And your trustees are like the directors in a company. And then you have your beneficiaries. So you can specify and limit or extend the beneficiaries that you would like to have in your trust. But what I mentioned is very important is that your property with substantial value, I usually advise that you put that in a trust. Why? Because this is how estates work. The master's office is there to deal with deceased estates. Okay, so an estate is essentially the property and wealth of a person who has died, okay, which can be distributed upon their death. Now, there are laws that are already there. The minute a person dies and they have property that needs to be transferred to another person or that needs to be sold and signed for, you have to register that property with the master of the High Court. You cannot just distribute things without going through the master's office. So you register with the master. And the minute you register with the master has a percentage that he charges of your estate, all right, for the services he's going to give you. And that can be between 4 and 5%. Okay, I think it was 4% before, but I'm hearing that it's gone up to 5% maybe. Then the master is going to appoint an executor who is the person who will be authorized. They are given the letters of administration. They'll be authorized to sign documents on behalf of the deceased estate. They'll be allowed to sell property on behalf of the deceased estate. Of course, if it's not yet wound up with the consent of the master, they step into the shoes of the deceased person. And that executor charges 4.3%. Okay, and I know there was a bit of a debate. I think there was a law that says, well, if it's a lawyer. But that's, of course, something that's still to be tested in the courts of law. So, but 4.3% goes to the executor. And then there is the death duty, or the deceased estates, or the, what you call it, the duty that you pay, or the tax that you pay by virtue of the fact that somebody has died, okay? And that estate duty can apply or might not apply depending on the value of the estate, but it can be right up to 3%. Now think about it, you add 4.3%, you add 4%, you add 3%, before you even go anywhere, you are almost on 12% of the value of your estate that is going to government instantly, just by the fact that you died. So imagine if you took your property is worth 300,000, your property is worth 150,000 or even 50,000, and you put them in a trust. Then what you put in your will are just the things which have less value, like your cows, like your clothing, like maybe 1 or 2 investments which might not be too substantial, and you put those in a will where you actually don't need to go through the master's office. All right. And that actually helps. So when you put property of substantial value in a trust, you protect that property from all these duties that have to be paid. should you die. And if you put them in a will, the master will deal with them, but the government will get their pound of flesh. So usually we advise people to say, wherever you can, whenever you can, please do put your property in a trust. And it's important even where a lot of people within our church and just generally, they are not in their first marriages. They are in their second marriages. And yet the property that they are in or that they are owning was purchased during the subsistence of their first marriages, right? And maybe he's a widower. And then they had a house. Then he's deciding to marry a second woman, right? Oh, sorry, to marry another wife, right? Not a second woman. And it's important that maybe you put in a trust that property that you purchased with your deceased spouse, and you put the beneficiaries, you restrict the beneficiaries to your children with that particular spouse, so that you have a clean start with this new spouse. Because surely what will happen is your wife has died and you have not dealt with the house. Obviously, the property comes to you as the surviving spouse, right? And that is the matrimonial home comes to you. And then, God forbid, you then die. You had married another woman. Guess what? The property goes to her as the surviving spouse. And we've had so many of those issues now where people are being chased away from home and they are saying, no, but this is our mother's house. It was bought before this woman came, or it was bought before this man came, and now it's benefiting his children, or whatever the case. That can be avoided by just settling and separating your estate so that it can benefit whomever it should benefit. I hope that one is very, very clear. Sorry, I'm just going to quickly check if there are questions. Okay. I don't know if I can go ahead and just read out the questions and try to attend to them. All right.
Yes, you may go on.
Okay, thank you. So I have one here that says, a woman was married or got married. Husband had a stand. Husband went abroad after paying lobola, and they had children. Husband worked and sent money to wife, I suppose, to build a home, and he started a company, etc. Now, due to 15 years apart, I'm sure you notice people can be apart for that long. Wife started having boyfriends. Question has, husband has now come back, and he saw text that she used to cheat when he was abroad for 15 years. He threw wife out after finding out. He stayed behind with kids and their properties. How can this wife regain what she lost? Her name is on the property and on the company too. Please advise. Okay. Well, there is a situation which is at least an easier case to handle, where the properties which were bought are properties that where the property which was bought are properties which had both their names on the property. And I think I stressed that it's so important that both names be on the property, because people get to a point where they're not getting along well. And when you're not getting along well, people always resort to the law. And so it's important that you handle your property issues in terms of the law. Don't do it emotionally or romantically. Don't do it in a way that says, oh, what does the church say? Most of the time, not most of the time, let me say many times, the church information that the church has falls far behind where the law is, So obviously programs like this are so important, because then we sort of bring the law and the current and what is currently applying to the church. But unfortunately, most of our pastors, because they still hold the old wholesome view to marriage, right? But unfortunately, that one, though, in terms of the church and in terms of the Bible, it is the highest standard for two married people to hold. But it will not stand in a court of law, where pastors will say to the, to the would-be couple when they're counseling them, to say, okay, now from now onwards, all the property that is yours is now his, all the property that is yours is now his, you are now a married couple, etc., etc. There's nothing further from the truth. Okay, and I think we need our pastors to be aware of that, so that we are not misleading our church members when they're getting into marriage, and they get into marriage relaxed, thinking that, well, that bicycle belongs to both of us, and etc. And yet when you come to a point where you're not getting along well and you're contemplating a separation or a divorce, you'll be shocked to actually see that if your name was not on the property, that property is not considered as your property. Okay. Of course, at divorce, the law will look at contribution, okay, to say what was your contribution, even if your name was not on the property. But that is if people get to a divorce. Sometimes people get to a death, and you find that the man in the will or the woman in the will put their uncle so and so, they put their mother, and they excluded you. As long as your name was not on the property, it can be put in a will to exclude you, as a husband. Okay, a person is allowed to do with their property as they wish, as long as they are the sole owner of that property. So they can bequeath it, put it in a will, sequestrate it, they can hypothecate it, they can mortgage it, they can sell it, they can dispose of it, and you'll be surprised, right? To say, no, but I know that we put his name because he's the father, etc., etc. But because your name was not on that property, well, you lose out. So it's important that our women in the church understand, and our men, especially in the church, understand that property that is being bought must have both names, right? They must have both names of the husband and wife in order to protect the rights of both. So the question that you've asked me both a legal matter and a moral matter. And I said the law will not moralize, okay? So usually with African men, this I just have to say, with African men, there seems to be some kind of a right to, if I can just say in simple terms, to cheat. But the same right is not allowed to the women. So this man comes and he finds texts from the woman that she was cheating, that she was having boyfriends, okay? That is a moral issue. And it's a matter that should be handled between the two parties. So you found that this woman was cheating. Are you going to divorce her or not? That's the question. You're going to forgive her and carry on and understand that you were away for 15 years. Then that's a moral issue and a moral question. But the legal issue is the fact that she was having boyfriends does not mean that it abrogates or takes away or diminishes her legal rights to the property by virtue of the fact that her name is on that property. Neither does it mean that just because the man caught the wife that she was cheating, assuming that she was, okay, that he also was not guilty where he was for 15 years. And usually, even if the husband cheated or he started having another wife, he went and paid lobola, in our society, it's supposed to be acceptable and expected, okay? And there are no financial repercussions, or property repercussions against the man. But somehow with the woman, okay, there is that expectation to say, oh, you must keep your fidelity, and if you don't, then you must lose everything. The law doesn't deal with that. Remember, I said the law does not moralize. The law just looks at it to say, oh, okay, you people contributed to this together, fine. Even if it was a direct contribution from the husband, but an indirect contribution by the wife, let's just say her name was not on that property. She has every right to claim that, in fact, she contributed to that property. Right, indirectly. So she was receiving money, but who was running around buying bricks? Who was going around getting contractors? who went and identified the stand and was sending pictures, who did all that, and who was looking after the family and the children while the man was abroad. All those are indirect contributions, which the law respects. So sometimes we tend to expect our moral disappointments to then affect people legally. Those two things are absolutely different. And if we just clarify and clear our minds about that, to say the law will not go and say, oh, because you cheated, then he's taking everything or she's taking everything. Please understand that. I think at some point it was like that, but it is no longer like that. Even where it comes to divorce, the court is not even looking at adultery. It just looks at irretrievable breakdown of a marriage. So with that, moral shortcomings do not have legal effects where it comes to property law. I hope that we are very clear on that. Sorry, let me just go to another question. Then it says, can you help clarify the law, how the law views a situation where a man is legally married, a civil marriage, this is chapter 511, and while married, he had children with another woman that he secretly married customarily. Then the married wife dies, and then he brings the other woman to live with him. Less than 6 months afterwards, the husband died. Does the second wife have a claim over the estate acquired jointly with the first wife? If so, does she have a claim over the children of the first wife? Okay, so no one has a claim over children that are not their children to start off with. Okay, but this man is married chapter 511. Let's start from the beginning. His married chapter 511 is monogamous. It means the woman that he secretly went and paid lobola for, and he entered into a marriage with her, that one at law is a nullity. It is null and void, okay? So it is not recognized as a marriage at all. And so we look at the time when the wife passed away. The wife passed away, and naturally, if the property belonged to both of them, the husband is the surviving spouse. He gets the matrimonial house and all the household effects, okay? Now, the fact that this woman has died, it does not mean that that woman who was secretly married, suddenly her arrangement, was elevated. She still remains, like her arrangement with that husband remains what? Null and void. So she comes in and he starts living with her, unless he goes and pays lobola again, as a free man, that marriage is still not recognizable. It means he just started kuchaya mapoto with this woman in terms of the eyes of the law. He just started living with this woman. And when he dies, she is not a surviving spouse. All right. Even if it wasn't 6 months, it was 5 years, she is not a surviving spouse. Maybe what she can claim under would be a civil partnership. Okay. To say, yes, I wasn't married, but I lived with this man for this long on a continual basis, on a genuine domestic basis, etc. And so at least I must get something. But the court would be looking at her contribution, just in the normal way that Section 41 talks about. We'll be looking at all those requirements that I read for you to see if this woman has any claim. But she is not the surviving spouse. She will not get the house at all, because this man will just be taken as a man who, was living in with a woman, or who was having a girlfriend. All right. And that is pretty much that. I don't know if I've answered everything on the, So no, she does not have a claim over the estate acquired jointly with the first wife. She does not. Unless she was then married. If he then married her after the wife had died, which had made him a free man, then yes, she would have a claim on the matrimonial home. She would become the surviving spouse. That's just how the law goes, and that's assuming he had not written a will stating otherwise. Otherwise, that property belongs to the children this man. Okay, so first of all, what would happen is they would need to wind up the estate of the woman who died, and then determine who owns what in terms of beneficiaries. Okay, sorry, who owns what in terms of the husband and wife, and then to say who is the beneficiary. And then when this man dies, they have to deal with the second estate now. Say, okay, so who are his beneficiaries? And yes, the beneficiaries, because now the property belongs to him by virtue of the death of his wife, it would include the children of this other woman, because the law does not look at whether you are legitimate or not in order to be a beneficiary in your parents' estate. I hope that one is done, in the words of Elder Machando Yafai. Okay. How much do you charge for trust? You'll have to inbox me for that, but definitely when we do trust for people who are coming in after these Zoom meetings or public presentations, we definitely give a huge discount, especially, you know, for fellow church people. Okay. What happens where both parents die before a trust has been registered and there are children left behind? Are they able to register property in a trust? Yes. So if both parents die, it means that usually when one parent dies, there's the surviving spouse who gets the matrimonial home and all the property in it. Then all the excess property is then what is shared equally among the children. Okay. And you know, if it is a civil marriage, it will also include the surviving spouse. Now, if both parents die, then the property is just distributed equally amongst the children, amongst the surviving children, okay, of this couple. All right. And then if it was property, of course, that belonged to the both of them. All right. Then if, let's say, there are no children, I might as well add this. If there are no children, right, and both parents have died, let's say in a car accident, then the next people in line to be beneficiaries are the parents, right, of these, what do I say? Okay, the parents of the deceased, right? And then if there are no parents, right, so there are no children, so the parents are the ones that are beneficiaries. If there are no parents and no children, then they look at the brothers and sisters. Okay, if there are no brothers and sisters, then they'll go and look at the nieces and the nephews, you know, the, what do you call it? The, the children of the siblings of the deceased people. So there is that chain of beneficiaries or priority in terms of beneficiaries. Okay. All right. So if a husband dies and he had other children outside of the recognized marriage, whatever his share of the property, those children will definitely benefit as beneficiaries. So again, I go back to say, the law does not moralize. The law just looks at rights of people. So all the children of this husband should benefit from their father's estate. But I must underline that that only happens where there's no will. So it's always important that one either has a trust or has a will. If you don't have a will, then the law will be applied as I have stated to you. Okay, but if you have a will and you've actually written a will specifying what should happen to your property, or if you own half of the property, to say what will happen to your half, the law will step in and then tell you that the surviving spouse will get this, and you know, the children will get the balance of the estate, etc., right? But what's important is write a will, you know, then everything will just go according to the will. Okay. Can I amalgamate property in both Zimbabwe and the UK into one trust? Yes, you can. Let me just go back up. I think I might have left one question. Okay. So I need to understand the difference between a trustee, a trust and a will. What is best to have if one spouse is to die? Okay, I think I tried to explain that a trust, with a trust, you're just transferring property to a legal person. Okay, so you register a trust, it becomes a legal person. It is given power by the law to buy property, to own property, to sell property, to extend the property, you know, to start a business using the property, etc. So you can have a trust while you are still alive. It's perfectly fine because you're the one who's essentially running that trust. Okay. And usually we say a trust is good in that it preserves it preserves value, or it's an investment. And the difference with the will is usually you will say, oh, the house in Kuwadzana, I'm giving it to my first daughter, and then the stand in Rua, I'm giving to my son, and then so essentially you have dissipated your estate or your property or your wealth, and the children can sell, and that's it. But when you are setting up a trust, you are determining what will happen to your estate should you die, without necessarily giving it out to beneficiaries who might get rid of it. So the good thing with a trust, if you leave it, let's say, to your children, they can also leave it to their children's children. You can actually specify in the trust to say, no, the property I've put in the trust shall not be sold except under these circumstances. So should you die, your children will carry on, okay, or your husband and children, or your wife and children will carry on with increasing the trust fund, and that can actually go on. We say a trust is perpetual succession, okay? It does not dissolve by virtue of you dying, because once you've put it in the name of the trust, it means that it is now property belonging to another entity. Okay, so like I said, it's not included in your estate, and it's much better usually because you don't have all those estate duties and all the fees that have to be paid. And I've noticed that sometimes a person will die, they don't have a will, they have a house in Warren Park, and they, you know, and they go register that house, and then the 4% that is required, okay, can come up to, you know, not even the 4%. Like I said, it can go up to 12%. So let's just say it's a house valued at 100,000, and you need to raise that 12% or so in order for the estate to be wound and for transfers to happen. People don't have 12,000 on the ready, right? So a lot of families have had to sell that house, which is the only property that is under the estate, and in order to pay the master's fees and everybody's fees. And then it sort of just defeats the whole purpose. Okay, so it's important. Imagine if that house, which is worth 100,000, was put in a trust, then you don't even need to go to the master to deal with anything else. You know, with clothes, you can just have a dare. With goats, you can just say, okay, what is going where, with scotch cards and, you know, that kind of thing, or other things where you don't have to worry about going through the master and actually being charged. All right, so I hope that that is clear. Okay. All right. A wife left for the diaspora, leaving a rocky marriage. After 3 years, they divorced, but the wife did not claim her share of the big house in Zimbabwe. They had one child growing up. The husband started cohabiting for a year before he passed away. They did not have a child together. Is his son the beneficiary of the house, or does this his girlfriend? Yeah, the girlfriend, like I said, that girlfriend. In fact, let me start with the first question. After 3 years, they divorced, but the wife did not claim her share of the big house in Zimbabwe. Well, you know what? If she didn't claim at divorce, the court settles issues at divorce. So in Shona, we say, if you did not mention that you need, that, you want a claim or you have a claim in the matrimonial property upon divorce, the court cannot guess. And the court may actually determine that you're not interested. And once the court is done with the divorce action and they have distributed the property, you can then go back and say, oh, I forgot to claim my share. So if the husband took the house and the house now belongs to him, and he starts living in, cohabiting with this woman, what happens is the property that is his remains his. This woman has no claim to the property that he has, okay, especially if that was given to him by court order, right? She has none unless she marries him. But even if she marries him, if you remember what I said, the property that belongs to him before marriage remains his personal property. So obviously, yes, the son would be the beneficiary. This other woman whom he was cohabiting with would not have a claim at all, unless she's saying she contributed something. And obviously, it's clear here that he got this property after his divorce. And my number, sure, I will write it down now. Sorry, if you can just I'm on my Zimbabwe number, and please, I ask that you send me a message rather than phoning. Then we can schedule when we can talk if we need to have a chat. So I've just put my number in the chat in the chat now. Okay, Elder, can we give it another 5 minutes so that I just quickly answer the last questions and we can close?
Yes, you can go on.
Okay. So I'll just answer these last questions. Then the other ones, you can be free to send them to me via WhatsApp. Can children register the property in a trust? Yes. Sorry, I did not answer your question. The children can register the property in the trust. Remember, these children who were left behind, they are the only beneficiaries. So yes, they can. All that is required is that an executor be appointed, and when that executor is appointed, the children can write affidavits to the effect that they are happy to have the property set up in a trust, and then that executor can do all the signing, can actually do the donation. And yes, the children as beneficiaries absolutely can register property in a trust. If a wife dies and leaves children, excuse me, if a wife dies and leaves children and had a property together with the husband, then the husband gives the house to other children of another woman he had, but not living with her, but lives with a different woman and no children together with the current woman who benefits from the property. Okay, we always have to go back to the original, excuse me. So if a wife dies and leaves children and had a property together with the husband, if she did not have a will, it means the husband becomes the surviving spouse, and that house goes to the husband. It's now his personal property, and he can do with it as he wishes. So he then gives the house to other children of another woman that he had. So I don't know if you say he gives the house, what do you mean? Did he donate it to them? Did he put it in his will? But if he gives it to the other children who are the children of another woman, children that he had, but he was not living with her, he's allowed to do that at law. He can, because remember that property now belongs to him. So really, it's to do with estate planning. You know, the husband can do with that property as he wishes, and can disinherit anyone he is allowed to do that. If he does it through a will, if he does it through a donation, he can even sell the house. Remember, I said that a person whose name is on the property, or who has inherited a property, can do with that property as he wishes. All right. And then he lives with a different woman and they have no children. So yes, the people that he has appointed to benefit from that house are the ones that benefit. All right. If the property, if both of them had their names on that property, then it's important that both of them have a will, you know, if they didn't do a trust, that they have a will that speaks to what should happen to the wife's half of the property. So she dies, but she had a right to write a will because she owned half of the property, right? And because of that, she can write a will and say, my half of this house or my share in this house, I want to leave it to so and so and so and so and so and so. But if she also dies and she has no will, remember the law then takes over. The law wants people to be organized. So you are organized by setting up a trust, you're organized by writing a will, you're organized, and that way you are handling your property and your effort in terms of what you would like. But if you don't do that, right, then the law is going to take over and just say, okay, oh, the wife has died, the husband is a surviving spouse, he gets the matrimonial home and all the household effects, right? And once he gets it, it's his personal property, he doesn't owe the children anything. He can even give it to the church and no one will argue, all right? So that's why we could constantly say, get organized in terms of estate planning. If you know that you had this wife and you are having another wife, deal with the children, right, of the first wife, then move on to deal with your issues with the second wife. Most men don't do that. Most women don't do that. They just get in romantically into relationships, you know, and they don't plan. And therefore they leave children exposed. Yeah, so it's important that you actually plan. Then I think the last question that I will answer is, how do I inbox you? Oh, okay, that's fine. I've already given you my number. That's all right. If you have 100 cows, can they go into a trust? Can cows get into a trust? That's a problem because cows die, you know, cows are killed for weddings, cows, all kinds of things. No, you know, you'd rather what you put in a trust is something that you can then register, okay? And that you can determine, you know, the value of, et cetera, et cetera. So things like a house, which you can then transfer, because once you do a trust, the next thing you do is to then go through the transfer process where you are transferring the property from your name or your names into the name of the trust, just like you sold the property or you bought a property. So there's no way where you'll be registering 100 cows, whether they are 500 cows or 1,000 cows, no. What is the least number of trustees required? 2. Yes, so two trustees. All right. Can you deal with my case if I'm a Berry resident? Absolutely. Yes, we can. I have put my number. If you just scroll up, you can see my number. And with that, saints, may I bow out. I will hand over to the elder and we can carry on with this conversation on my app. Please do send me a message. Don't call directly because sometimes I'm in the UK, so I might have family engagements and I might not be able to immediately attend. So please just send a message and let's get on with it. I'm here and I'll be happy to assist. God bless you.
Excuse me, sister. Your number is not appeared in the chat.
I have actually. Okay. Let me.
I can't see it myself. I don't know others whether they see it. I don't know.
I've just put her.
But I have your number anyway myself.
All right. Yes, of course. All right. So let me. Do you mind just putting it on the chat then, Elder?
I will do so.
Okay. Excellent. Otherwise, I'm handing over to you now.
Thank you, mate. You're an absolute gent. Cheers, bro.
Thank you.
Thanks, mate.
let me take this opportunity to thank Sister Nyari, Advocate Nyara Zaimaposa. We want to thank you for the work well done. There are a lot of questions people have been asking and so on. Someone asked me a question soon after a presentation in Luton. I am happy that it has been answered because she was telling me that the sister had to take some days off to go and protect her house. She was told that the husband had taken, what do we call it, a girlfriend into the home or small house. So she was told that the small house can claim the house if they stay together. I think that question has been answered very well when you were explaining about the prejudice. I think all of us we have understood. I know this is a huge topic. We have different questions. Probably all of the questions may not be answered on this forum, but here is Advocate Nyari Maposa. We can give you the number and you can call her at your own time so that your questions may be addressed. I believe that you are with us again tomorrow according to our arrangement, Advocate Maposa.
We will finalize on that, Elder. Yes.
Okay.
We'll finalize on that.
That's all right. So let me just take this opportunity to say thank you very much. We will keep on benefiting from the lessons you have given us or the presentation we have had today. I just want to ask all the members who are here to unmute themselves, and we thank Advocate Maposa. Those who are able to unmute, what does the church say to thank Advocate Nyari Maposa?
Amen.
Oh my God.
Amen.
Amen.
Amen. Amen. Amen.
Put the number there. The number.
Come again tomorrow, please.
Yes. So thank you very much. I would like to hand over back to Sister Patience, who is leading us on this forum tonight. There are some who have questions. You may send them to Sister Nyari. If you are not able, you may send them to me or whoever, then we will pass them for addressing. Thank you very much. God bless.
Amen.
We still can't see your number.
Thank you.
Can you please just say it so we can type it into our phone?
One day, but investigate.
Thank you. I'm going to ask Sister Nyari to close us in prayer, and then we can say good night. And
right, shall we pray? Father in heaven, we are so grateful for the time that we have had tonight. Thank you, Lord, because you have said in your word, my people perish because of lack of knowledge. What a sad situation it is, Father, where your children who are carrying the light into the world are not knowledgeable in the ways of the world. Remind us all the time, Lord, that as we are under the church and as we are Christians, we are still under the jurisdiction of the laws and the rulers who rule over us. Help us to be wise. Help us to understand indeed the state of our flocks and our herds. Help us to know, dear Father, that there will come a day when we have to face our resting time, and that it is part of the Christian requirement that we leave our houses in order, so that after we have gone, your name can continue to be blessed and praised, and we can continue to be a good example even to the world. We know that estates are the cause of the greatest breakdown in family relations. May it not be so with us, dear Father. Continue to give us wisdom and to have the desire to know even more. I pray, Jehovah, that even those we'll be interacting with, may they also find a blessing, dear Lord. And may we take this message even to others and apply to our families and extended families, so that this can benefit even more people. Let your name be glorified. Bless everyone who logged on and those who shall receive the information. For we have prayed in the holy and precious name of our Lord and Savior, Jesus Christ. Amen.
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 Thank you,
Amen.
everyone. Thank you,
Amen.
Sister Mary. Have a good
Amen.
night, everyone.
Amen.
Amen. Amen.
Amen. Good night.
Good night.
Good night. Good night.
Good night.
Good night.
Amen.